There have been several developments related to the Oxford school shooting making headlines today, including the parents of the shooter being granted separate trials in their involuntary manslaughter case.
Also, in the wake of the Guidepost Solutions report on the shooting, which found it was preventable, an organization made up of Oxford parents is demanding the immediate resignation of anyone whose action or inaction may have contributed to the shooting.
Joining us now to sort through it all is criminal defense attorney and former prosecutor Todd Flood. Thank you so much for being with us.
Thanks for having me.
So, Todd, let's start with the separate trials component of this. There had been some concern from prosecutors in recent weeks about the trials being combined. Apparently, some new information has come to light, and the judge has granted this request. So what do you make of that?
I think there was a conflict from the very beginning, and a hearing had to be set basically to have the conflict waived. But when you try criminal cases and you have multiple defendants, it's not a team sport, right? You as a defense attorney, have to do everything in your best interest to represent your client. In this particular case, it was fraught with many conflicts, especially those for which you had at the outset all those text messages from one of the parents, not both of the parents. So and that could be used potentially if there was one jury. They could consider the text messages from one of the defendants. In this case, due process, the Constitution, everything with regards to ethics, you knew that someone was going to throw someone under the bus. It wasn't new evidence, really. And so I think ultimately at the end, this is the right call. The sad part about this is instead of having one trial with two juries and just having one jury step into the jury room during the testimony of one of the defendants, if they so choose to testify, or for testimony that's going to come in that could implicate the one defendant that, let's say, for example, the wife text messages something that could implicate the husband. All of that material should just be excluded, and we could have one trial. Here, you're going to have two trials, two separate juries, and it's going to waste a lot of taxpayer dollars. It's going to ultimately bring in and trigger so many witnesses to have to do this on multiple occasions, which is really the sad part. I would prefer to have two juries, one trial, and just separate the jurors when there's testimony that comes in. It happens all the time throughout the state. Primarily a lot in Wayne County. So unfortunately, it's not going to happen here, but the prosecution's right. They only want to do this once. They don't want to do it twice. And the defense has the right to have separate trials. So it's a no-brainer to me.
How does this impact the prosecution's case? Does this make their job easier or harder?
No, I don't think it makes it more difficult. There is going to be testimony that's taken in one trial that can be used at the second trial, for sure, for impeachment purposes. But, you know, when you're a prosecutor and you have to call in witnesses on multiple occasions that have seen this ugliness, that have seen and are triggered by all of this, that is gut-wrenching. This is the biggest case in the country for this type of activity. And it's difficult, but I have seen the prosecution's case unfold, and they have all their T's crossed and I's dotted. I firmly believe they'll be competent and ready to go to trial. I don't think having a second jury is going to, in this particular case, make it more difficult for them. It's just difficult in the sense of having to shepherd all the witnesses and have them go through all of this.
Todd, as we run low on time here, do you think there's any chance that this separation will lead to a different outcome for either of these parents, or are they likely to end up with the same result, just, you know, arrived at separately?
I don't think it's going to come out with a separate result. I do. There's one thing that, and I think we forewarned, you and I have talked about this before. We thought, you know, that this was coming. We predicted this was coming. One thing that I think I'm concerned about is the fact that one of the defendants shared secrets with the other attorney. So if they had a joint defense agreement and there were secrets that were shared, those are sacrosanct. So God forbid there is some sort of recusal of one of the attorneys because he has secrets of the other defendant. I don't think, to answer your question, this is going to be due process. Whatever the jury decides, let them decide. Win, lose, or draw, let's get it to a jury. Let's 12 people decide the fate of this case and end this chapter, because this is a chapter we do need to end.
Yeah. Well, that is coming up soon, January 23rd. Todd Flood, criminal defense attorney and former prosecutor. Thanks so much for joining us today, Todd.
Thank you.